believe we have 105 people registered for this webinar around the country today. So very warm welcome. We have a massive room or electronic room full of people. My name is Monique Charland and I'm the CEO of the National Franchisor Company, which is Business Accounting Network, or better known as BAN. And I'm sure for most of you, the title, as Shane says, of our webinar today, The Dirty Dozen, the Most Dangerous Agreements on Earth, couldn't keep anyone away from attending. It's just out of curiosity for the title. Now, as business owners, irrespective of how small some of our businesses might be, we are already overwhelmed by the sheer volume of laws and regulations that govern our everyday lives. There's nothing more daunting as a business owner, though, than preparing contracts for our own business, as well as signing contracts. And many of us just don't read what we sign. And that is not a wise decision, as the consequences of simply not reading a document can far outweigh not doing so. Our presenter today is Robyn Hey of Robyn Hey Attorneys, and admitted attorney to the High Court. And she's a strategic BAN Alliance partner. Now, Robyn has over 20 years experience in law, with many years in one of the largest law firms in South Africa, before starting her own practice over 10 years ago. And Robyn specializes in commercial law, with particular emphasis on commercial contracts, business rescue, liquidations, commercial litigation. And I'd like to introduce you shortly to Robyn, but before I do, just a little housekeeping before we get started. We'd obviously love to hear from you and any questions you might have. So if you do have any questions during the presentation, please type them in to the box on your right-hand side. And we, or Robyn, will answer those questions right at the end of the webinar. So without any further ado, I would like to cross over today to Robyn Hey. Warm welcome, Robyn.
For joining us on our webinar today. The reason that I'm doing these agreements is primarily because I do commercial work. So I combine my commercial work with a real understanding around distressed businesses. And in almost every scenario, there are a couple of agreements that upend either a business or a business owner during difficult times. And these are the agreements that I wanted to go through today. Now, we are going through 12. So some I'm going to go into more detail than others. If you've got any questions at the end, or if you would like me to contact you to chat through anything more, my contact details are available on the slides, and I would absolutely love to assist you. One of my primary passions when it comes to law is to really assist business owners in creating sustainable businesses. So Monique's already introduced me, which is very kind of her. And although she thinks I have more than 20 years experience, it's just because I'm very gray from years and years of doing law. I've actually only got 16 years of experience. I've run my own practice since 2008. And as it says here, my passion is future-proofing businesses. So it is in that context that we deal with the dirty dozen. And the reason that these are important is that these agreements fight back. So you sign them, you think everything's done, and then before you know it, pow, you've got something revolting coming out of the woodwork. So let's start with the first one, and I've cheated a bit because I've put two of the dangerous agreements together because they go together and the nuances are quite similar. So the first, and should be the least surprising for you, is a surety and a guarantee. Now, the difference between a surety and a guarantee is as follows. A surety is what we call an ancillary agreement, whereas a guarantee is a standalone agreement. So what do I mean by that? You sign surety, let's say your company takes out a loan, you sign surety for that company if it doesn't pay, all right? A guarantee says you will pay on the happening of a following event. So whether or not the company has paid, the creditor can come after you specifically whether or not the company has paid, provided certain things have happened. So the first thing you need to do is be very, very careful that you know whether you're signing a surety or a guarantee. And from that perspective, it can really make a difference and can really upend you. And then some of these are very simple questions. Do you know how much surety you're signing? Sometimes, for example, the banks will say to you that you're going to sign surety for everything that could ever be charged by anyone in the whole universe, and you must pay the bank that money if the principal debtor defaults. And the answer to that is no. If the loan is only a million rand, then you only sign R1 million worth of surety for that particular loan. And don't be afraid to stand up and say that, because the bank doesn't need more security than that. Then you need to look at how long does a suretyship obligation last. Again, you'll often see in sureties, especially with finance houses or big companies, where it says it lasts forever. It's a continuing covering security. So what that means is, even if the debtor's amount owed to the bank, for example, goes to nil, if in the future they owe money, that surety revives. And there's no reason why that should be the case either. Because you may leave the company, your child may, if you've signed surety for a student loan, your child will then finish their student loan, and if they get themselves into trouble because they don't pay for their overpriced avocado toast down the line, that shouldn't be your problem. Now, one of the things that you also need to understand is that the surety is limited to, your rights as a surety are limited to the rights of the underlying agreement. So if, for example, your underlying agreement is not covered by the National Credit Act, so in other words, it's too big, so it's over 250,000 Rand, it's a large transaction, then you're not entitled to any of the protections of the Consumer Protection of the National Credit Act. You're only entitled to the protections of the National Credit Act if the underlying debt is protected. So that's a nuance that that's something you really need to run past an attorney. Then the other thing you've got to look at is whether you're a surety or a surety and a co-principal debtor. So now we're really delving into the things you need to know, but will keep you up at night if you do know. So in its purest form, a surety says, if person A doesn't pay, then I will pay. So you first have to go after person A, and then you can go after person B. But the most common scenario is that you sign as surety and co-principal debtor. So what that means is you are the debtor in parallel to whoever you're signing surety for. So let's say your company's borrowed R1 million and you've signed a surety and co-principal debtor. That means you also owe R1 million. So the bank can never recover more than R1 million, but you're both equally on the hook. So if your company defaults, but you've got lots of assets in your personal name, then the bank could go after you whether or not they've gone after the company. And then, can you cancel the surety or the guarantee? That is a question I get all the time. Now, normally you can only cancel a surety or a guarantee, provide the wording of the document's important. You can normally only cancel it provided that there is no underlying debt. So it would have to be paid up, and then you can cancel. You can't normally cancel while there's any amounts owing. And that becomes tricky if you're a director of a company and you've signed surety and you leave that company. Sometimes you may still be on the hook for the money that accrued up until the date you resigned, because you're still on the hook for that, or you'll be on the hook going forward. So when it comes to leaving companies or changing your positions within companies or divorcing a spouse or anything like that, you need to make sure that your surety, wherever possible, is terminated at the same time. So then we move on, and I'd actually at this point like Shane to run the first poll.
So the results of that first poll, we've got 77%, that's nearly 80, very close to 80% saying no, which is kind of what you were expecting, I believe. Back to you. Thanks, Robyn.
Don't worry, at the end of this, you'll all be running off to find a lawyer, don't you worry. So then we look at supply agreements. This is when you are supplying, as a business, you're supplying another business. I often see these really take out a smaller business. You need to understand what you must supply. What is the order process? Do you need a purchase order? Is it cash on delivery? When is the money paid? Who's entitled to place the order? Because often I see supplier, people who've taken delivery of goods say, oh, well, you know, Santi sent the order, but she's not authorized. It should have been picked, and we told you that in the beginning. So you need to understand that. You need to know, how does the order process work? What are the specifications? If you're supposed to deliver 10 widgets, what must those widgets look like? And when must they be delivered? Who carries the cost of delivery? Do you need to include in your cost the cost of actually getting widget from place A to place B? How do you deliver it? Do you put it on the ocean? Do you put it on a truck? Do you put it on a train? And what insurance do you need in order to do that? Is it an exclusive arrangement? Are you the only supplier that they're allowed to use? If not, how do you build that into your agreement so that if they suddenly stop using you, that your whole business doesn't fall flat? And then this is going to sound very silly, but which entity are you supplying? Do you think you're supplying Robyn Hey Pty Limited, but actually at the bottom of the invoice in tiny print, it says Monique Charlin CC? You've got to know exactly who you're invoicing. Are you going to be forced to sign any kind of surety? Are there any tax implications to what you purchase, to what you supply, where you supply, local versus international? It's not just a matter of buying widgets from China and then selling them on to someone else. It just doesn't work like that. It's a high risk agreement. So apparently is a webinar. One moment. There we go. Now I'm going to deal with two different kinds of leases. The first is immovable property and then movable property. So immovable property is buildings essentially. So the first thing you need to know is this a commercial property or residential property? A residential property is, you as a lessee, you're protected by the Rental Housing Act. So there's legislation that really does protect your rights, and the Consumer Protection Act applies if you rent in your personal capacity. Now, there's no such protections under a commercial lease if you are signing as a company. If you're signing a commercial lease as an individual, you still have the protections of the Consumer Protection Act. If you are signing in your own name or the name of the company, it really, really does affect your ability to get out of the agreement. If you are a company and you're leasing from another company, for example, your early termination provisions don't apply. So you can't just get out of the agreement on 20 business days notice as you can if you're an individual. So it's an important distinction to make. You may want to decide who, if people normally, a lot of people say, I want the lease agreement in my company. Well, that's fine, but you don't have the same protections. What is the period of the lease and what is your total rental obligations? Especially if you're renting from a shopping mall or from any kind of office building. Do you have to pay turnover rental, operational rental? Do you need to pay sewage separately? Do you need to pay for maintenance? What are your levies? What about the common areas? So you may think that your rental is 10,000 Rand a month, but by the time you've added everything together, it's 25,000 Rand a month. And then you suddenly find you're trapped in a 5-year lease with a rental that is excessive and you can't get out. And rental and leases in a commercial setup almost always include a surety. And the number of times I see a business collapse because of a lease and the director or shareholder collapse because the fact that he or she signed surety, I can't even begin to tell. It's one of the most common scenarios. Then you've got movable property. Again, movable property is things like, are you leasing a photocopier? My advice to you is if you're going to lease a photocopier, make sure you know what's going on, because those agreements are one of the most revolting set of agreements. I apologize to anyone who rents photocopiers. It's really a tricky agreement, and it's the same with if you are leasing water coolers or you're leasing cars or you're leasing anything that's movable. Are you signing in your own name or in the name of the company? Again, if you're signing in the name of a company, you don't have the Consumer Protection Act, the protections there. Again, what is the period of lease and what is the total rental obligation? So are there maintenance contracts? Are there service contracts that you must take out? If you default on the actual lease of the photocopier, does that mean that the maintenance or service contract comes to an end? Because sometimes it doesn't. Sometimes it runs parallel, and then you have to go and fight about the fact that if you don't have the photocopier, how are you supposed to pay for something, for a service that maintains it when you don't actually own it? So it can get very tricky and very ugly. Are there confidentiality clauses or IP clauses that place obligations on you? Are you renting something or leasing something that is cutting edge, where there's intellectual property rights, where you've got to have confidentiality clauses or non-disclosure agreements? How the hell do you get out of the agreement? It's remarkable how many people don't know that. They think, oh, I'll just give notice. It's not just give notice. There's often very specific things that need to happen. What are the penalties? What is the suretyship? So you'll see there's themes that come up again and again when it comes to various agreements. You'll see common threads that come through. Then we go to company documents. We've got company documents MOI and company documents, which is the second one, shareholders agreement. The very first question I want to ask you, and Monique will be jumping up and down for joy when she sees this, is why are you forming a company? Is it because your mother's brother's uncle's best friend who did 1 year of law in 1985 is telling you that you must form a company? The answer is no. Unless you're going to have a huge capital layout, it may, or the tax or your turnover is going to be massive from the beginning, or there are any tax reasons, or you are going into business with more than one person, you do not need to necessarily start a company. You can wake up on Monday morning and start doing business as a sole proprietor. And that may be much more appropriate for what you're doing. Then the question is, are you really forming a company? People will come to me and they'll say, no, I've got a company. I then look at their documentation. They've got a CC, or they've got a partnership, or they don't have anything, or they mill around not knowing. Guys, if you're going to go into business with someone, it's like getting married. You need to know what you're getting into. And you need to know whether you're both getting married, or one of you is living together, the other one's got an open marriage. You know, it's like that kind of thing. Why is it that you think you're in a company when you're not in a company? Because everybody tells me, no, we're in a company. And I'm like, no, you can't just decide you're in a company. You've actually got to register a company. Then the other thing is, if you are in a CC, please convert your CC to a company. It's not a massive thing to do, but as long as you're in a CC, you have to comply with the obligations of the Closed Corporations Act and the Companies Act. In the past, being in a CC was a really helpful thing because it had far fewer statutory obligations than a company, but that's changed under the new Companies Act. Now, your entry-level companies are really as low maintenance to run as a CC is. And one of the reasons that I hate CCs, and I hate them with every fiber of my being, is that they are very hard to get in and out of. They are very hard to limit what your member that you're in the CC with can do. It's very hard to deal with death of a member. It's very hard to just deal with the practicality, because unlike a company where you have shareholders and directors, so shareholders own and directors control, in a CC you've got a merging of those two concepts. So you've got ownership and control, and it's just one thing, and it's just a mess. So you'll often see family businesses stay in CCs, and then when Uncle Simon wants to retire, he just wants to go, he wants his members' interest, is only an association agreement, and it's just one big omni-shambles. So if you're in a CC, convert it to a company. Don't be afraid, you're all going to be fine. Nobody's going to steal anything from you. Just do it. Go and see your lawyer, go and see your accountant, and sort it out. Then for an MOI, you must understand that's a public document. So it's registered at CIPSI, which used to be CIPRO, and it contains exactly what shareholders and directors can and can't do. So what are the powers of the directors? What are the powers of the shareholders? Who is going to be doing what and in what capacity? How do you run meetings? All of that. You need, the minute you have more than one of you in that company, you have to get a shareholders agreement as well, which is what we're going to deal with. The best time to put all your get all your ducks in a row is not when everything is falling apart, but when everyone's playing nicely in the sandpit. So during the honeymoon phase, when you're setting up a company, that's when you need to do the hard work and put the proper agreements in place. Then I want to ask you as well, why do you want to be a director? And do you know the implications? It's not just about having the word director on your business card. It's about making sure that that company is run in accordance with the Companies Act. And although the new Companies Act is a lot shorter than the old Companies Act, the obligations are serious. And no, you do not have to run around like Harvey Specter in suits trying to negotiate every single day, but you do need to understand what your obligations are. Which brings us to our next deadly agreement, which is your shareholders agreement. Now, your shareholders agreement is not a public document. Your shareholders agreement, and this is what people often forget, they think, well, if I've got my MOI, that's fine. But your shareholders agreement deals with things like, how do we deal with disputes if we can't get along? How do we exit the company? And what must the company pay for our shares if we exit the company? If you cease being employed by the company, do you have to give up your shares? What is your dividend policy? These are things that you don't want the whole world to know. These are things that you want to be able to negotiate privately between you and your other shareholders. You want to have certain resolutions that can only be decided by shareholders, so that your directors don't run amok, so that your directors don't go and run up debt in the company or change the business of the company. So one minute you're making coffee machines, and when you look again, you're selling a fleet of trucks. You want to make sure that the directors who are the controllers of the company do not run off and do what the owners of the company, being the shareholders, do not want them to do. You also need to have a look at whether or not you're a minority shareholder. I can't tell you how many times somebody comes to me and says, oh, I own 15% of a company, and I want to sell my shares and I want to make R1 million, and then I want to go and retire in Bali. I'm like, that's a very tall order. If you're a minority shareholder, you have to have minority protections built into your shareholders agreement. Yes, they exist in the Companies Act, but they are complex and they don't always work for smaller companies. In fact, they don't always work for bigger companies. So you need to use your shareholders agreement as any other contract. In what is expected of me, what do you expect from me, what do I expect from you as a fellow shareholder, and what are things like profit share? What are things that we don't want the whole world to know, but that is bespoke to I hate that word bespoke. Whenever somebody says that, I think, oh yeah, fine. But anyway, let me try that again. What is particular to your company that you and your shareholders have agreed can be or will be part of your relationship? The reason you have to get a lawyer to draft both of these is because your MOI, if the pawpaw hits the fan, your MOI overrules your shareholders agreement. So you need, in terms of the law, so you need to have your shareholders agreement and your MOI dovetailing with each other. Shane, at this point, can you run our second poll, please?
That's quite interesting. It's actually more your attorney, which you're probably going to be a bit disappointed to hear.
Really?
Yeah.
Oh, well, that's wonderful.
I know.
Except that means you guys have an attorney. So why are you sitting here listening to me is my real question.
Yeah. Anyway, 43% have voted for attorney, 41%
well done.
very close second, and then only 16% have selected I draft them myself. Back to you. Thanks.
Listen, 41%, you are going to get yourself in massive trouble, because I often see it. Somebody's downloaded some agreement and they found it and it looks fabulous, but it's governed in terms of the courts of Quebec. It refers to things that we don't have in South African law. It just isn't applicable to your business. It's got all the things that you don't need and none of the things that you do need. So it makes me want to weep. There are certain agreements you can download off reputable websites. So if you go to some of the law firms, you'll see that they've got some downloadable documents that you can buy. But please, like, honestly, don't do that. And if you do it, take it to a lawyer who will clutch their chest, fall to the floor, but help you in any event, because we see that all the time. So the next one that is very tricky to sign are your employment agreements. So you need to understand, and this is not a labor law webinar, so I'm not going to go into massive detail about the Basic Conditions of Employment Act and the Labor Relations Act, because that's a whole story on its own. But you need to know, how does that apply to you? One of the things you really need to know is, what is your company's grievance procedures? We deal with a lot of employment law, and let me tell you, it's a complete monster. Because if something goes wrong as an employee, who do you speak to? How do you deal with it? How do you get heard? Must you send something to an HR department? Must you send something directly to your line manager? It all gets very confusing. If your company doesn't have a grievance procedure, then you need to chat. If something does go wrong, you need to get an attorney's opinion before you start sending emails that include words that rhyme with duck, because then it becomes very difficult for us to manage. Do you have clear KPIs? The reason, or key performance indicators, the reason this is important is if it all falls apart and now suddenly your boss doesn't want you anymore and decides to have a disciplinary hearing, then you need to say, okay, these are the 10 things that I was expected to do, and this is how I did them. And that's important so that it both gives clarity for the employer. So if you are having a troublesome employee, you can actually hold them to a specific standard. And for the employee, well, you can say to a boss that's maybe abusing his or her power, look, this is what you told me to do, and this is what I've done. And if there's something wrong, you need to show me, but I really have complied with everything you wanted me to do. You also, sorry guys, you also need to read and understand these kind of clauses. So a non-solicitation clause, which does not mean you may not prostitute yourself, restraints of trade and confidentiality clauses. A non-solicitation clause means that when you go, you can't take your company's staff or clients with you. Now guys, seriously, that happens all the time. So you're currently working for, I don't know, Lily Sales, and Lily Sales sells plants, and you get a job offer from Rose Sales, which also sells plants, and you go across and you take your Lily Sales customer with you. That is very bad, okay? Even if the agreement doesn't specifically say that, there's common law which prevents that from happening. So don't do that, okay? And if somebody in your company does that, please go and see an employment lawyer, hashtag Robyn Hey attorneys, because we can help you with that. Most attorneys that have an employment law speciality can deal with things like that. Restraints of trade. Every time something goes wrong, someone will come to me and say, oh, well, restraints of trade aren't enforceable. I think you'll find that they are enforceable. And we have successfully implemented restraints of trade on many occasions. There are certain requirements, there are certain legal responsibilities, and at the same time, they are doable. So please, if you are an employee and you're leaving, don't be an idiot. Go and see your lawyer. Go and see exactly what you're allowed to do if you've signed a restraint of trade. And likewise, if you're drafting an employment agreement for your employees, put in your restraint of trade. Don't try and stop them from breathing in the country, but there are certain things you can restrain them from doing. And lastly, confidentiality clauses. So if you work in a very highly regulated industry where there's IP or any very specific services, then you can't take that information with you. So if you work for KFC, you can't take their secret spice with you. Now, likewise, if you work in IT or you work in any industry where there's very confidential information and you have access to that confidential information, that needs to be regulated in your agreement. And even if it isn't regulated in your agreement, again, you can't use it. So employers that are listening to me, you need to get your employment agreement sorted. This is also something you can't just download off the internet. Depending, the more and more specialized your staff member is, the more and more detailed and specific these kind of areas of the law need to be demarcated. Credit agreements. Now, I could go on about credit agreements forever, as you can imagine, but I won't, you'll be happy to know. As you can imagine, I see a lot of these, and they are very damaging. So the first question is, have you read the agreement? If you haven't read the agreement, then you are not being very clever. And in almost every credit agreement, so remember, that's a credit application to do business, that's a loan, that's an overdraft, that's anything where you are supplied, where you're given credit. And you'll see one of my points is it's a deferred payment, so you're given an opportunity to pay something off. There's interest charged, and or there are any costs charged. Now, just that definition alone is fairly technical, so I'm not going to get into it. But read the agreement, understand the repayment terms and any penalty clauses. Please look and see if you supply or you provide surety. People tell me, no, it's not valid surety if it's just somewhere in an agreement and I sign it. Yes, it is, in fact, valid surety. You need to have your attention drawn to it, but there's no reason why, if it's not in some kind of case law, that it can't be, if it's not in some kind of separate document, that it can't be used against you, that you haven't signed a suretyship agreement because it's not in a separate document. So what happens if you lend money to your friends and family? Well, the courts have decided that if you lend money to friends and you're making a commercial benefit, so you're lending money to your family or to your friends, and it's a commercial transaction as though they were strangers, and you charge interest, that is a credit agreement, and you have to register as a credit provider. So if you lend money to your best friend, you're going to have to register for as a credit provider unless certain specifications are met. So don't go around lending money to your peeps. You need to actually have a proper agreement in place, understand how the interest component would work, how would you manage to regulate that agreement, and what are the requirements if you have to register as a credit provider. On the other hand, sorry, let me just start by saying, if you don't, it's your agreement, if you don't register, it's likely that your loan agreement will be void. At the same time, you're not just going to be able to keep the money, people, if you've got it on the other side. So if an agreement is void, if you've borrowed the money, you must return it, and people have to be put in a position that they had the agreement never been entered into, and or there may be what we call an enrichment claim. So you got money, you were enriched by a certain amount of money. So it's not like, let's borrow money from someone who's not a credit provider and I can run away forever. No. And credit agreements are very, very, very complex and very technical. And don't sign any credit application or any credit at all unless you have taken it to a lawyer. I know that sounds extreme, but you need to actually consider the long-term implications. If you have a credit facility of 2 million Rand and you've signed surety for it, that's a problem. The other thing is, if you are providing credit, you'll be astonished, or maybe you won't be astonished, maybe you'll hang your head in shame, that a lot of people don't know who they're lending money to. So again, it will say, the credit application will be completed by Robyn Hey on behalf of Robyn Hey attorneys, but actually you're lending money to Charlene Smith attorneys. Like, you just don't know. So you need to have surety documents. You need to have a checklist of what you need in order to prove that that person is who they say they are and that the surety is who they say they are. Because it happens all the time where you've got the name is one name, the registration number is another name, the surety is a complete mess because it doesn't say who is lending the money, who pays the money, how it must work, and it only ever becomes relevant when it all falls apart. And we're all desperate for business. I understand that. We all want the business, but a non-paying client is worse than no client because they mess with your cash flow, they cause you to run up legal fees, and they sap your energy as a business owner. So just be careful. Then offers to purchase, right? If you're buying a house, there are things you need to consider. Again, this is a whole webinar on its own, but look at simple things to start with. Firstly, the minute you get that agreement, you must take it to a conveyancer. Now, that may sound extreme as well, but it's one of the most important things, whether it's a residential or commercial property. It's one of the biggest investments you're ever going to make. And nobody wants to lose their house. Nobody wants that deal to fall through. So going to see a conveyancer needs to happen before you sign anything. And it just must happen. You need to find a reputable conveyancer. It doesn't need to be the person that the estate agent recommends. Ask around, just like you wouldn't just go to any doctor. Don't go to any conveyancer. Ask your friends and family. Phone your commercial lawyer and say, or your accountant, and say, listen, who would you recommend? Get the right person. And it can be all very overwhelming, but the right conveyancer makes a massive difference. So have a look at things like, must a deposit be paid? If so, when and how much? Look at, again, who is buying the property and who is selling the property? Who is on the hook to do what? Are there approved plans? Is the title deed, does the title deed set out the property descriptions? I can't tell you how many times I get it, where people come to me, now they've bought this house and they think that they're buying a hectare of property, and then suddenly they realize that the boundary wasn't in the right place. So actually they're only buying 3/4 of a hectare or half a hectare. It really happens all the time. So please have a look at that. Are there any conditions precedent? Must there be a bond? When is the bond approval? How long do you have to get a bond? And also, just because you want to get out, it doesn't mean you then just can't apply for a bond because you think, that'll get me out of it. Remember, there's estate agents commission. And often whoever breaches the agreement is on the hook for that estate agent's commission. Even though usually the seller pays it, if the purchaser stuffs up the agreement or breaches the agreement, then that purchaser is on the hook for the estate agent's commission, and you do not want to be on the receiving end of an angry estate agent. They are relentless. They are like SARS. They never stop coming. Then you must have a look at what must be done to the property before transfer and who must pay for this. Who has to pay for the beetle and electrical and the compliance certificates and the electric fence certificates and the gas certificates? Those are normally paid by the purchaser, but make sure that's what's said in the agreement. Have a look at, must the damp in your property be dealt with? Do you need 4 coats of paint and 3 ceilings of the roof? Does the footstrips clause apply? And the footstrips clause applies even under the Consumer Protection Act. If there are latent defects that the seller didn't know about, and you buy the property footstrips, it sucks to be you. It is still part and parcel of our law. What furniture, fixtures, and fittings are included? Is your lovely oak bookcase that you've bolted to the wall, have you specifically said you're taking that with you? Because otherwise it's a fixture. It's actually part of the house. And then what? Then you have to leave your oak bookshelf behind. And I have to tell you, that happened to me once. And I've never sobbed so much about a bookcase in my entire life. So it's a very painful memory. So offers to purchase have their own problems, and make sure that you read them properly. Going on with that, do you deal with vacant occupation? So one of the things that is an absolute nightmare is you're buying a property, there's some tenants in it, and the seller says, oh, no, don't worry, they'll be out. But you don't have a vacant occupation clause in your agreement. You then get transfer, you get the property, and guess what? The tenants are not out. Now you must evict them. You need to make sure that there's vacant occupation, that they note that it's the seller's problem if the tenants won't get out. Know what you're actually buying. Like, are you also buying a parking bay? Is the parking bay included? Is there a garage? Is the garage included? There are all these things that you have to look at. And then finally, have all the blank spaces been filled in and witnessed? There's nothing worse for yourself, for your estate agent says, and I'm not knocking estate agents, they've also got jobs to do. They say to you, don't worry, I'll fill this in. And then they make a mistake, or they put the wrong information in, and then you're bound by it. So make sure all the blank spaces are filled out. Okay, anti-nuptial contracts. Yes, this too is an entire subject on its own. But essentially, what are the options for matrimonial property regimes? If you don't sign an anti-nuptial contract, you're automatically married in community of property. So it's what's mine is yours, what's yours is mine. And people say to me, oh, I don't want to sign an antenuptial contract because our love will last forever. Maybe your love will last forever, and I pray that rainbows and unicorns will adorn your life. The truth is your partner may die, and they may die without a will, or they may die with a weird will. One of you could be sequestrated because you go into business. If you are in community of property, then both of you are sequestrated if his creditors come after you, which means you will lose everything. So if your properties are, if your assets are in one person's name and not the other person's name, you've got a better chance of saving your assets. So if you're in business for yourself and you're married in community of property, best you start some estate planning. That would be a very good idea. Then you've got out and out. So that's ANC is out of community of property, and there's no accrual. That means what's mine is mine, what's yours is yours. And you've got to specify that in your antenuptial contract. And then what is the accrual system? So the third one is out of community of property with accrual. And there it really, and this is a very simple definition, it can get very complex. It's the calculation that says how much the spouse with the larger estate must pay the smaller estate if the marriage comes to an end through death or divorce. So you start off an asset base, then you look at the growth, and whatever the growth is, the difference between the growth for the higher earnings, higher capital spouse to the lower capital spouse is split. So you really need to understand that. And the number of times somebody comes to me and there's a problem in their business and I say, how are you married? They go, I don't know. Did you sign an antenuptial contract? I think so. Guys, no. Warren Buffett once said that one of the most important financial decisions you'll ever make is who you marry. And that is absolutely true. It's not only who you marry, it's how you get married. You need to have that information. You need to see a neutral lawyer. Don't go and see your best friend who's also a lawyer, because that person's not going to be neutral. Go and see someone who is not interested or not invested in either of you, that can help you have those hard conversations. Oh, sorry, I've said the lawyer must be a registered. He or she must be a registered notary, because you need to notarize your agreement. You can't contract out of your ANC or community of property. You can't say the accrual won't apply. You can't contract out of this. And then the last thing to note is that you can change your matrimonial property regime, but it costs you a fortune. It's a high court application, and you've got to advertise to your creditors. All sorts of things have to happen. So you're looking at between 25 and 50,000 Rand. So go and pay your 5,000 Rand before you get married and get a proper antenuptial contract in place. Otherwise, come and see me and I'll happily take your 50,000 Rand. It sounds exciting. So the last one I want to deal with are agreements with professional service firms. For some reason, you'll see the most bullshit people in the world walk into my office or their accountant's office or their tax practitioner's office and absolutely turn into jelly. You have every right to negotiate this contract as every other contract. When it means negotiate, you can always say to your attorney, is this up for negotiation, or I'm only prepared to do that? The attorney can say yes or no. You are allowed to actually stand your ground. So find out what the hourly fees are. Do you know how few people ask me? They walk into my office, what they will say, or they walk into my boardroom, they will say, are you charging me yet? Are you charging me yet? I'm like, no, everybody calm down. I'll meet with you and then I'll quote you. Or, or I'll say, look, the initial consultation, if it's a very complex matter, is this, and then going onwards, this is how we're going to charge you. And you have the right to know what that is. You also need to know what scope of work. So if you go and engage an accountant, are they going to do your tax work? Are they going to just do management accounts? Are they going to draft annual financial statements? How often are you going to get management accounts? What is it going to cost you? But when you go to these meetings, make sure you know what you want. Don't go in there and go, oh, well, what do you think? Because we don't think anything until you've told us what you want and what the facts are. Honestly, we're very good at what we do, but our crystal balls are murky. So you need to be very specific about what you want. Check out the qualifications of the professional. Just because somebody's divorce was done brilliantly by lawyer A doesn't mean that that lawyer is able to deal with a commercial matter. Like, don't come to me for divorce advice. Nah, I'm not your person. I'll refer you on to a great divorce lawyer, but I'm not that person. Ask a lot of questions. What will happen here? What happens if this happens? Can you tell me what the normal process is? How long will this take? Ask those questions. Sometimes the answer will be, I can't tell you that right now, but these are the next steps. And that's also an answer. Must you pay a deposit? How much? Is there a trust account? Are there any disbursements? And what is your responsibility and what is the professional's responsibility? Because you need to know where your responsibility ends and somebody else's responsibility begins. Because I often get clients that will say to me, oh, well, tell me what to do. No, I can tell you what your options are. I can help you make a decision, but ultimately I can't tell you what to do. I can tell you what factors to consider. I can tell you what I think won't work, but it's not my responsibility to help you make those life-altering choices for you. And the other thing is, if I make a choice for you and it all goes to hell in a handbasket, you are going to sue me. And I like my house and I don't want to sell my cats on eBay so that your abdication of responsibility can be paid for by me. Now, it's the same with accountants. Accountants have certain responsibilities, but it depends on the information you give them, like the information you give us. We are not psychic. We don't know if that information is correct or incorrect. We can only work with what you give us. We can ask questions, we can probe, we can say, this doesn't look right, that doesn't look right. But ultimately, if you tell me that this is what happened, and you give me certain documents, I can ask and ask and ask and ask, but I may miss something because you haven't given me everything. And I've seen the same with accountants. I've seen accountants draft annual financial statements based, or management accounts based on information given to them, which is completely wrong. And then at the end of the day, the business turns out to be distressed, but nobody knew because nobody had given, the business owners are not given accurate information to their professionals. So that's the end of all my information. I hope it wasn't too fast, but I wanted to leave time for questions. And then the last couple of slides are just about what kind of services we offer and how to get hold of me. But more than anything, and I know this is not very lawyerly, whoever you go to is your responsibility or your choice. You need to go to an attorney, an accountant, whatever it is that suits you. It's like choosing a psychologist or a doctor or a partner. They may be wonderful people, but they may not make you feel comfortable. So don't feel pressured by anyone to take their advice. Shop around, do what you need to do. But please, 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 more than anything else, please get the right advice, because you will be very sad if you don't. So, Margaret, the answer to that, firstly, is that the Labour Relations Act and the Basic Conditions of Employment Act, you can't contract out of them. So what they cover, they cover. Your employer or you as an employee can't contract out of it. So they can't say that they don't comply with it. And if there's nothing mentioned about family responsibility, then yes, ask about it and make sure that it's added to the agreement, because your family responsibility leave is limited in terms of the Act. So you really want to have that set out clearly. Because I'm a lawyer, I read that question, it's a little unclear for me. If you're talking about, can you moonlight? So in other words, you work for me as a lawyer from 8 to 5, and then you do your own legal work on the side. The answer to that is, unless your employer agrees to that, no. It also means that especially you can't do work on the side for the same clients. And the reason for that is that you're actually then competing with your employer for the same clients. If you're asking me, yeah, I think that's what you mean. So if you want to do other work at work, whether it's the same, whatever it is in your private capacity, you would have to get permission from your employer. I hope that answers your question. I hope I haven't been too vague. I'm not 100% sure if that was what you were asking.
On the legal side, is agreements between my clients, my engagement letter, and also between my subcontractors or outsourcing of work. That's the area which I'm busy. I've got some information. I've got one of a guy up in Joburg recently, but the bottom line is that's the area which I was hoping to maybe acquire some additional information and to get someone of legal astute to basically review that type of stuff, because I've got a couple of drafts which I need to use. I'm also busy opening up a new practice at the moment.
David, you are absolutely right, because those are your core agreements. So if you don't have those wrapped up, you're going to have a serious problem, and you're also going to struggle to get your external, your contractors in and not to steal your clients. So one of the things that we're very particular about, especially for professional services or knowledge workers, is that your terms and conditions are absolutely watertight, and your infrastructure and support agreements, which is really what you're looking at, your contractor agreements, have got very, very tight protections for you, so that you don't have people running off with your clients, because that's everybody's worst nightmare.
Just to have clarity on the restraint, my understanding is that you can't just say that there's a restraining order, because you may not allow people, so you are not permitted to restrain a person to do the work in the type of industry or profession he or she's educated and experienced in. But you need to pay for the period of restraint. Can you just clarify that for us and the audience?
Yes, so, okay, so, sorry, I don't mean to cite you, Lindy, but the first thing is you can't just restrain someone. You're absolutely right. You can't restrain someone from using their brain. So, for example, let's just take my firm as an example. I can't stop my attorneys from being attorneys. I can't say you may never be an attorney again. But what I can say is for 6 months or a year or 2 years, they cannot contact my clients. That's your anti-solicitation clause, your non-solicitation clause. I can say that they can't use my precedents. I can say that they can't open a practice similar to mine within a 10 or 15 kilometer radius. Whether or not you have to pay for that, now that becomes very technical, because it depends on whether or not, what kind of knowledge they've got. So an attorney, my attorneys can go and be attorneys. It's not that they need to be paid for that, but your protectable interest. So what is it that you're actually getting, that you're actually protecting? So if, for example, it's something that results in them not being able to work at all, and you need to put somebody on gardening leave, then that's what you need to do. But the thing with restraints is that they just are not, they're not one size fits all. So in every case, you have to consider every aspect of that restraint differently. Specifically to that particular client. So no, you can't just restrain somebody from, for example, being a lawyer. But if it's a very specific area or using very specific tools, then you can restrain them without having, with using those particular tools or contacting your particular clients, and you can do that without paying them, depending on the circumstances.